January 21st. And pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive meeting was held on January 20th, 2016 to review matters that are by statute 65 PACS 708, 1108 confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review of confidential opinion requests, the review and consideration of applications for 90-day extensions of investigations filed by the investigative division, and the review of pending litigation. An executive teleconference meeting was held on November 13, 2015 to review matters that are by statute, 65 PAPS CS 708, 1107, confidential, specifically to discuss litigation. With that, first item on the agenda is to approve the minutes of the October 7, 2015 public meeting. Melanie makes a motion and Roger seconds it. All those in favor signify by saying aye.
Aye.
Nay. The ayes have it. Second item, civil penalty order consent. Melanie Palmer.
Thank you, Mr. Chairman. There's one civil penalty case with a proposed consent agreement that is now before this commission for decision. This case involves respondent Carol Boyle. Parties have submitted a consent agreement proposing that the commission find that Ms. Boyle failed to timely file a statement of financial interest for calendar year 2013 and impose one civil penalty in the amount of $250. Ms. Boyle has paid the recommended civil penalty but has not filed a delinquent form. Based upon my review of the facts, I am of the opinion that this consent agreement is consistent with commission precedent and is a proper disposition for this case. It is also my opinion that the commission should order Ms. Boyle to file her delinquent statement of financial interest for calendar year 2013. There is nothing of record that would constitute a defense or excuse for her noncompliance. Based upon my analysis and comments, I would like to make the following motion. I move that this commission approve the consent agreement submitted by Ms. Boyle and the investigative division impose a civil penalty in the amount of $250 for Ms. Boyle's failure to timely file a statement of financial interest for calendar year 2013. Further, Ms. Boyle shall be ordered to file a complete and accurate statement of financial interest for calendar year 2013 with the Pennsylvania Department of Aging and to forward one copy of such filing to this commission for compliance verification purposes within 30 days of issuance of the commission's order.
Motion is made by Melanie and seconded by Mark Corrigan. Any questions? All those in favor signify by saying aye.
Aye.
Nay. The ayes have it. Item number 3, Roger, Water Disclosure Law.
There are 4 administrative penalty cases with proposed consent agreements for our consideration. I'd like to take 3 at this time. The following respondents are principals that failed to timely file a quarterly expense report for the first quarter of 2015 or the second quarter of 2015 in their capacities as registered principals. Elon Group Ltd., Lehigh Valley Zoological Society, and Pennsylvania Consumer Credit Association. In each case, the parties are in agreement that the respondent's transgression of the lobbying disclosure law was negligent. None of the respondents have paid the agreed upon administrative penalties and cost reimbursements, but all of them have filed the delinquent expense report. Based upon my review of the facts, I am of the opinion that the consent agreements are proper dispositions for the respective cases, and I would like to make the following motion. I move that this commission approve the consent agreements submitted by the investigative division and each of the following respondents and impose the following administrative penalties. As to Elon Group Ltd. and Lehigh Valley Zoological Society, 1 administrative penalty each in the amount of $3,150 for their delinquent expense reports for the second quarter of 2015. as to Pennsylvania Consumer Credit Association, one administrative penalty in the amount of $500 for its delinquent expense report for the second quarter of 2015. I further move that each of the aforesaid respondents are directed to pay the agreed-upon additional $250 payments to be made to the commission, representing a portion of the costs incurred by the commission in the investigation and enforcement of their respective matters. Finally, I move that those respondents who have not yet paid the administrative penalty or additional payment of $250 are directed to do so within 30 days of the mailing date of the commission's order.
Motion made by Roger, second by
Second.
Judge.
Yes.
Willis? Any questions? All those in favor signify by saying aye.
Aye.
Nay? The ayes have it.
There's one additional administrative penalty case, and it's my understanding that Commissioner Feely has recused herself from this.
That's correct.
Okay. The following respondent is a principal that failed to timely file quarterly expense report for the first quarter of 2015 or the second quarter of 2015 in its capacity as a registered principal. Novell Inc. Respondent Novell has already paid the agreed-upon administrative penalty and cost reimbursement and has filed its delinquent expense report. Based upon my review of the facts, I have the opinion that the consent agreement is a proper disposition for the case, and I would like to make the following motion. I move that the commission approve the consent agreement submitted by the investigation division and impose the following penalty. As to Novell Inc., one administrative penalty in the amount of $2,660 for its delinquent expense report for the first quarter of 2015. I further move that the respondent be directed to pay the agreed-upon additional $250 payment to be made to the commission, representing a portion of the cost incurred by the commission in the investigation and enforcement of the matter. And finally, I move that the respondent, who has not, I'm sorry, they've already paid theirs, so skip that. That's my motion.
Roger makes the motion and is seconded by Judge Lewis. Question? All those in favor signify by saying aye.
Aye.
Nay? Ayes have it. The next one is the Jones determination. Mark Corrigan.
Mr. Chairman, I would recommend that at this time, that the commission immediately go into executive session for the purpose of quasi-judicial deliberations to discuss the new matter that has been submitted to us by Mr. Jones, and see if we have any other questions about this opinion.
Okay. Anyone have a problem with that?
Welcome back.
What?
Thank you. The requester in this matter is Mr. Mark Jonas, and he is the solicitor for the Montgomery County Development Corporation, which I shall refer to as the MCDC. The question presented is whether service as members of the board of directors of the MCDC would bring that those board members on whose behalf Mr. Jonas has inquired within the definitions of the terms executive level public employee or public official as set forth in the Gaming Act, and would therefore cause them to be subject to the restrictions of sections 1512A, A.1, and A.2 of the Gaming Act. The question that is behind the stated question is whether the position of MCDC director should be included on the list of government positions meeting the aforesaid definitions, which list is maintained by this commission pursuant to sections 1512A.52 of the Gaming Act. The commissioners have all received the lengthy submitted facts, which include the history of the MCDC and its role as a certified area loan organization and as a certified area loan organization for the Department of Community and Economic Development, as well as a certified loan provider for the Pennsylvania Industrial Development Authority. I will not recite all of those facts, but will focus on the following facts. In 2014, in the course of a merger with another nonprofit corporation, MCDC reestablished itself as a member organization and revised its bylaws. MCDC is a 501c3 development corporation. It is a membership-based organization that consists of approximately 800 members. Although MCDC was originally created by Montgomery County, any person or legally constituted business entity may now become a member of MCDC by applying and paying the membership fee. Each member is entitled to one vote at all membership meetings of the corporation. The board of directors of the MCDC consists of 17 directors, with 8 directors elected by the county board of commissioners and the 9 majority directors elected by members of MCDC. Vacancies on the board are filled by the county commissioners. MCDC considers itself to be a private, nonprofit, non-governmental organization. MCDC contends that it is not a governmental body under the Gaming Act. Attorney Jonas asserts that because MCDC is not overseen or controlled by a governmental entity, it is not an agent of the same. No MCDC members are employees of the MCDC. The submitted facts state that MCDC members are not involved in the development of law, regulation, or policy relating to a licensed entity or other matters under the Gaming Act. It appears that what has triggered this inquiry is that in or about 2014, DCED local share account approved a $200,000 grant to be utilized by a business located in the county named Blommer Chocolates. Per the LSA guidelines, MCDC was the applicant on behalf of Blommer Chocolates and received the loan on its behalf in October 2014. The loan was provided from funds received under the Gaming Act. This particular grant was approved for the purpose of the site improvement work by Blommer Chocolates. Mr. Chairman, I would suggest that this would be an appropriate time for any interested parties to speak on this matter.
Seeing no one.
Mr. Chairman, I have reviewed the facts and the relevant statutory provisions. None of the 4 numbered paragraphs in the Gaming Act's definition of the term executive level public employee would apply to the board members in question. Paragraph 1 of the definition would not apply to them because it lists particular public positions that they do not hold. Paragraphs 2, 3, and 4 of the definition would not apply to them because they are not MCDC employees. Likewise, none of the 5 numbered paragraphs in the Gaming Act's definition of public official would apply to these board members. Paragraphs 1 and 2 of the definition would not apply to the board members because they do not hold the positions listed. Paragraph 3 of the definition would not apply to the board members because MCDC is not a county or municipal office. And it is my view that paragraphs 4 and 5 of the definition would not apply to the board members. In the absence of an applicable statutory, regulatory, or judicially approved definition that would include a nonprofit member organization as a governmental body, it is my view that for purposes of this Commission's duties under Section 1512 of the Gaming Act, the MCDC is not a governmental body. Therefore, neither paragraph 4 nor paragraph 5 of the Gaming Act's definition of the term public official would apply to these board members. I note that we are not deciding their status under the Ethics Act, which uses a different definition. Given this analysis and comments, I would like to make the following motion. I move that the holding of this commission in this matter be as follows. Based upon the submitted facts, service as members of the Board of Directors of the Montgomery County Development Corporation would not bring the directors on whose behalf Mr. Jonas has inquired within the definition of the term executive level public employee as set forth in Section 1103 of the Gaming Act, or within the definition of the term public official as set forth in Section 1512B of the Gaming Act, and therefore would not cause them to be subject to the restrictions of Section 1512A 8.1 or 8.2 of the Gaming Act.
Second?
Second.
Any discussion? All those in favor signify by saying aye.
Aye.
Nay? Ayes have it. Next item, Judge Lewis, item number 5.
Item number
the Sonia-
5.
Sonia Barber.
Yes. The requester in this matter is Sonia Barber. Ms. Barber is the spouse of Lance Barber, who is another requester on this agenda. Ms. Barber has been elected to serve as an auditor for Plain Grove Township. Ms. Barber holds a license with the Pennsylvania Harness Racing Commission to own, drive, or train standard-bred racehorses. Ms. Barber has contacted various entities, including the commission, to ask whether serving as a township auditor would jeopardize her license. Given the commission's limited jurisdiction under the Gaming Act, we may only address whether service as a township auditor would bring Ms. Barber within the definition of the term public official as set forth in 1512B of the Gaming Act, and therefore cause her to be subject to the restrictions of the Gaming Act at section 1512A, paren 8.1 and paren 8.2. Mr. Chair, I would suggest that this would be an appropriate time for any interested party to speak to this matter. All right. Mr. Chair, I have reviewed the facts and relevant statutory provisions. It is my view that subject to certain conditions, Ms. Barber would not be a public official as the Gaming Act defines that term, and I make the following motion. I move that the holding of this commission in this matter be as follows. Based upon the submitted facts and subject to the conditions that, 1, Plain Grove Township does not directly receive a distribution of revenue under the Gaming Act, and 2, the township is not involved in the development of regulation or policy related to a licensed entity or in other matters under the Gaming Act. Ms. Barber's service as a Plain Grove Township auditor would not bring her within the definition of the term public official as set forth in section 1512B of the Gaming Act, and therefore would not cause her to be subject to the restrictions of sections 1512A, paren 8.1, paren 8.2 of the Gaming Act. However, it should be noted, our written determination shall include the fact that the township auditors are public officials as the Public Official and Ethics Act defines that term, and the township auditors are subject to the restrictions and requirements of the Ethics Act. That is my motion.
Motion by Judge Lewis, second by Roger. Any discussion? All those in favor signify by saying aye.
Aye.
Nay? The ayes have it. Next, this is on Lance Barber determination, where it is, right?
The facts pertaining to this request are as follows. The requester is Lance Barber, an elected Pennsylvania constable who holds a license with the Pennsylvania Harness Racing Commission to own, drive, or train standard-bred racehorses. Mr. Barber has contacted various entities, including this commission, to ask whether serving as a constable would jeopardize his license. Given the commission's limited jurisdiction under the Gaming Act, we may only address whether service as a Pennsylvania constable would bring Mr. Barber within the definitions of the terms executive level, public employee, or public official as set forth in sections 1103 and 1512B of the Gaming Act, and therefore cause him to be subject to the restrictions of the Gaming Act at sections 1512A, 8.1, and 8.2. Mr. Chair, I suggest that this is an appropriate time for any interested parties to speak on this matter.
May I continue?
I have reviewed the relevant statutory provisions and facts. We addressed the same question in Benestad Determination 13-2003, and it's my view that we should reach the same conclusion as we reached in that determination. Based on my analysis and comments, I move as follows. I move that the holding of the commission on this matter be, based upon the submitted facts, Mr. Barber's service as a Pennsylvania constable would not bring him within the definition of the term executive level public employee as set forth in section 1103 of the Gaming Act, or within the definition of the term public official as set forth in section 1512B of the Gaming Act, and therefore would not cause him to be subject to the restrictions of section 1512A, 8.1, and 8.2 of the Gaming Act.
Motion by Ms. Haley, second by Melanie. Any questions? All those in favor signify by saying aye.
Aye.
Nay, the ayes have it. Item 7.
Item 7, there are no new payment schedules. Everything's continuing as we had. Almost everyone is, we have a few delinquent individuals who haven't been making payments as we entered into the agreements, and the Brian and Jeffers file enforcement actions and come along.
Very good. I'm to make an announcement on the election of officers pursuant to Commission Resolution 85-002. A notice of election must be publicly announced at least 30 days prior to such election and forwarded to all members of the commission. Therefore, the Pennsylvania State Ethics Commission hereby announces that an election of officers will be conducted at the next regular scheduled meeting of the Pennsylvania State Ethics Commission for the purpose of electing a chairperson and vice chairperson, as the term of office for the chairperson and vice chairperson expires on April 25th, 2016. With that, anybody have any questions or want to say anything for the good of the order? A motion by Roger, second by Melanie. Meeting is over.